suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And David Whiting is a Melbourne solicitor here to give you some free legal advice. Good morning, David. Nice to be back in the studio with you.
Yes, likewise. Yeah.
You don't have to
I
say
took
that.
2 weeks off, you took a week off.
Oh, there you go.
Balance.
Do you have homework for
I
us?
had no homework.
No homework. Okay, let's go to Ryan in Altona. Ryan, what's your query?
Yeah, thank you. My young nephew has got casual work at the Royal Show this year, and he's promised employment, but today he's been told to turn up for training for an hour and a half, and he's not going to get paid. Now, is that legal?
Yes, it is.
Sorry?
Yes, it is. It is possible for training to be at your risk and cost. But it needs to be real training. It can't be sham training. But you're going to work at the show. Whoever you're going to work for needs to know that you understand the systems and, in a sense, that you become productive as an employee the instant you start in that role. So, yes, it is not illegal. I know that's bad language, but it's not unlawful to impose a training obligation, provided it's real training. And I would have thought 90 minutes training is pretty reasonable.
Okay. No, that's all right. Well, it's being an unemployed person, there's a cost associated to turning up to that.
Yes.
Yes.
So, and that's a little unfair and a little bit miserable. But, okay.
I think it kind of depends on the training he gets and whether it's value, and if it turns into 10 days of paid employment, I think that's fantastic.
Okay,
Yeah,
Ryan,
he's
that
not-
answer your query?
Yep, it does. Thank
Okay,
you.
good luck. Thank you, Ryan. Amanda is in Hughesdale. Amanda, what's your question?
Oh, good morning, Raph and David. My sister-in-law lives with my mother-in-law, and recently my mother-in-law changed her will so that my sister-in-law is able to stay in the house for 7 years after her passing. I was just wondering what the implications are of that, please.
So your mother-in-law has given your sister-in-law what we might call a limited life interest, the right to live there for a period of time. The answer is in your mother-in-law's will. So does it happen? Yes. Quite often you'll see that one partner might own the house before the relationship starts and includes in their will a provision that their partner can live in the property after the first person dies, sometimes until they die.
And there's no tax implications, no stamp duty or anything like that?
No, and there's no capital gains tax implications. The
Right.
property's still considered to be an asset subject to whatever tax concessions currently exist in relation to the property remain. But every now and then you find that someone, because normally there will be a power of sale, that if this property is sold and one bought as a replacement property, then capital gains tax kicks in. So at the moment, the answer will be no capital gains tax consequences of the interest being given to your sister-in-law.
Oh, terrific. That's great news. Thanks very much,
Thank
David.
you.
Thanks a lot, Amanda. Fiona is calling from Preston. What's your question, Fiona?
Hi. Just as a motorist, I was recently involved in a collision with a cyclist where the cyclist crossed against a red pedestrian light. So my insurance company is saying that the collision is my fault because I didn't give way to the cyclist. They say cyclists have right of way at all times, even if they're doing the wrong thing. I'm just wondering if that is correct.
I don't accept that, Fiona. I don't see that the cyclist is always right. There'll be an apportionment, and the answer would be we're all expected to keep a proper lookout. So no, it's not an absolute every accident between a cyclist and a car is the liability of the driver of the car.
Yeah, so that's the insurance company's ruling on it rather than the law.
Well, so you have an insurance policy, and are they refusing to pay because it's your fault?
They're saying that I have to pay the excess rather than the cyclist.
Oh, okay. All right. Why don't I give you a better answer next week, Fiona? But certainly there is no absolute favour for the cyclist.
And so just to clarify there, Fiona, your insurance company says it's your fault, so you should pay the excess. Your argument is the cyclist insurance company should pay? Is that
No, the cyclist, no. What Fiona will have is a no-blame policy, right? So if it's not
Right.
Fiona's fault, Fiona doesn't pay the
Got it.
excess.
Okay.
Okay?
So we're getting halfway there, aren't we?
Yeah.
Okay. Fiona, thank you. A little bit of homework for David. Please hope that's okay that you listen next week and get a complete answer. Liam is in Bayswater. What's your question, Liam?
Morning, David and Raf. Questions about a tree that's about a metre on my side of the fence line. Now, the next door property is currently vacant. It's a vacant block, and they're developing it into 3 single-storey units. And the developer's been in touch offering to remove the tree.
Liam, how big is the tree?
Sorry?
How big is the tree?
10 to 12 metres.
And how far around is the tree? What's the diameter a metre from the ground?
Diameter would be 50 centimetres.
So why would you go and have a talk to the council or have a look on their website, have a look at their local laws and see if they have a tree policy that may impact upon your ability to do anything with the tree, having regards to its size. The issue from your neighbour's point of view is that your tree's roots will be encroaching, and it may also be that branches will be overhanging.
The branches certainly are overhanging.
And that impacts on your neighbour's ability to construct what your neighbour wants to construct. That's the issue. The law was developed at a time when the whole of your tree was on your property. Now, as we live closer together and closer together all the time, trees will overhang. Roots will encroach. So the issue is your neighbour's entitled to say, I want your tree off my property. And a possibility would be a root barrier. So you would put in a root barrier and you would then trim the tree to make sure that the branches don't create a problem for whatever the builder is putting in. It's the balance of, I want the tree, but the neighbour's got to be able to build what the neighbour basically wants to build.
Is the root barrier their responsibility?
No, they're your roots, mate. So you've got to keep them on your side of the fence.
Okay. They've offered to remove the tree and replace it with a 4-metre tree at their expense.
Yes.
Would that be the...
Well, it seems to be. I mean, I understand the need to keep things green. There are benefits in having trees. The question to my view would be, what kind of tree do you want? Is it appropriate to move it a bit further away from the fence? So they're the kinds of discussions. I would have thought it's not a bad deal.
And there's also a question, is there a question there of whether or not council lets you cut it down?
Well, I've had some issues with Burundara and with Stonington. They have local laws relating to tree cover. Burundara has a policy of requiring coverage. So, look at the Knox Council website and see what their law is in relation to trees. At 10 to 12 metres, it may be a significant tree, and there may be a significant tree policy that needs to be addressed.
Okay, Liam.
All right, thanks for that.
Good luck. And Ishad is in Geelong with a question for David Whiting on 774. What's your query?
Good morning, David and Raf. I operate and drive a taxi, and last year I was involved in an accident which was a lane change, and it was my fault, and my car is insured with a club insurance, and I paid for my fault. I paid the excess because I was in the wrong. And I have been receiving the bills from the other lawyers of the other party that I need to pay, and I keep forwarding that to my insurance. And last week I got a letter saying that a court order has been the court has ordered that I need to pay all the costs involved, and when I ask my insurance, they do not give me any concrete reply. So now I have got another hearing next month in the magistrate's court, so I don't know what to do in this situation.
Hey, do you know any other people who are, you know what club insurance is, Raf? It's a group of like-minded people who decide that they will put money into a pool out of which cars will be fixed when they get damaged. So taxi drivers spend a lot of time on the road. There are a number of taxi clubs that effectively decide that they will insure each other. Now, it may be, and some of them work really well, some of them don't work particularly well. I got a letter earlier this year in relation to one that was now closed. So really the question would be, Ishad, I'd be going and knocking on the door of the taxi club and saying, well, your deal was that you would insure me, you would provide for the damage caused to the other car, and you haven't. Now, as between you and the, for want of a better word, the not negligent driver, it's your problem. So what you may have ended up with is you may have what amounts to a contract with insurance with an insurer who doesn't have any money to pay or doesn't have enough money to pay. So your first thing you got was a notice that a judgment or order had been made against you. Now what you've got is a summons for oral examination where somebody puts you in the witness box and asks you questions about how much do you earn and what do you owe, so that they can work out the best way of getting money from you. I would have thought your starting point has to be a visit to the taxi club to say, why aren't you paying?
Okay, Ishad?
Yeah, they do not even reply. It is very, very hard.
No, visit, Ishad, not emails are very easy to ignore. It's going to require you to knock on the door. And just to find out the truth so you will know what to do.
Yeah. Good luck, Ishad. I hope that works. That's just one first step that you can take. David Whiting is here to answer a question from Bill, who is in Perth. Bill, what's your query?
Yes, hi, Dave. Look, my query relates to a funeral home which advertises a 24-hour service and includes sort of grief counselling or references to that on their website. So this relates to their website. But when you phone them up, they then say it's when you phone them up after hours, they say it's an after-hours service, and they phone back during business hours. And what I'm asking is the advertisement on the website fraudulent? Because
I don't know that fraudulent is the word. Deceptive and misleading, downright wrong. But fraudulent I'm not prepared to go to.
But it is misleading and deceptive.
Well, absolutely. If I don't offer a 24-hour service. Now, even people who offer 24-hour services sometimes have downtime.
Yeah.
But no, I would have thought not. I don't know you'll prove fraudulent, Bill, but I've got no difficulty with deceptive and misleading and wrong.
Okay.
Does that answer your question, Bill?
I've got one more. Would that be a thing the ACCC would look at?
Yes, they would.
There you go.
Yep.
Okay.
Okay. Good luck, Bill.
Thanks,
Thank you.
Thank you.
That's an interesting one. 24/7. This is
well, people die at very inconvenient times, Raph, right? And you want someone to come and pick up.
Of course you do. Of course you do.
Take someone into their care is the phrase.
Yep. Sadly, I've been there. Adam is in Hampton. What's your question, Adam?
Good morning, gentlemen. My query is about taking an item to a dry cleaner and having it come back completely ruined. I'm just wondering what my rights are there. Are they responsible? Are they supposed to replace that, or is there some form of compensation I can get? Just wondering what the sort of stance is there.
You could go to VCAT and your claim would be measured as your loss, and that would normally be the value of the clothing that was trashed or destroyed. Now, having said that, Adam, you need to understand that most dry cleaners display clauses limiting their liability.
Mm-hmm.
Now, so you need to go down and take a picture of what the limits of their liability are, and then there'll be a question as to whether the limitation of liability clause was reasonably brought to your attention so you were aware at the time it happened.
Yeah, it's interesting because I was very clear when I dropped it off, because it's a new dry cleaner, and I specifically said, do you do this particular type of dry cleans it. It's a letter P with a circle. You're supposed to use it's a designer item.
Yes.
And you're supposed to use a very specific chemical, is what I understand.
And they said they
said, yep, sure, no problem. And they took it off me, and it came back.
And up. Yep.
Yeah.
Yep.
Yeah.
Have you asked them to replace it or anything like that?
I have to some degree, and what they've offered is they're trying to find a replacement. But the thing is, I bought this brand new from New York. I don't know what condition they'll find a second-hand one in. They don't make them anymore, all that sort of thing.
Then what you want to do is try and find out what the market value of the item is.
So it's market value?
Yes.
Yeah, okay.
Can I say you need to appreciate that it's not always going to be replacement.
Mm-hmm.
And I think the best example of that is remember we used to buy film to take pictures?
Yep.
The liability on the package was to the replacement of the film, not for the replacement of the wedding
images.
that was being taken to bought the pic camera
Ouch.
for.
Right, okay.
Thanks, Adam.
Good luck.
Thanks very much. Thank you.
Mary is calling from Broadford. Mary, what do you want to say?
Hello. Look, this is a good day to call. My query is similar to the lady talking about her sister-in-law. Property that was left as a life interest to a family member. Now, it was a stupid will. It was a badly drawn up and designed will. That estate's not going to be settled probably for another 70 years.
Wow.
And
It's a life interest to a 2-year-old or something, was it?
Was to an 18-year-old.
Okay.
Okay.
Yep.
Now, State Revenue Office says, give us land tax, please. But my understanding is that...
The answer's in two parts, Mary.
Okay.
The executors of the estate are the primary persons responsible because they are the registered owners of the property.
Right. Okay.
Now, you then need to look at the terms of the will to see whether they have the right to recover that from the tenant.
Okay. All right.
Right, so a normal life interest clause says that X needs to pay all of the rates and outgoings assessed in respect of the property.
I don't actually think it says anything like that.
Then you need to get someone to have a look and just to answer that question.
Okay, all right.
Sorry for ruining your day.
No, the SRO told me that it was a property trust, and I said, well, the Australian Tax Office disagrees with you. And they went, oh, all right, fine. So we'll just charge you at the normal rate, not at the trust rate.
Yep.
Okay, that's nice. But it looks like we are liable for the land tax.
That's right. There are some questions that arise where there is a beneficiary living in the property.
Yes.
How long ago did this person die?
10 years.
And there were some changes made around that time. I'll take it as another piece of homework. Mary, listen next week.
Yep, I shall.
Thank you.
Thank you for your help. Bye now.
Good luck, Mary. 25 past 10, David Whiting answering your questions, Legal Talk Back with Juliet, who's in Moonee Ponds. What did you want to ask, Juliet?
Oh, good morning. Mine relates to a heater that, or it was a inbuilt heater that I returned to a company, and they haven't come back to me with the price we agreed on. What had happened was I had moved into a brand new apartment, and there was this fire unit there, which I didn't use, which I bought off the plan, but I realised that it just wasn't suitable, so I didn't use it or anything. I rang the company and they said they would take it back. They'd give me about half price for it.
So you bought a unit that had a heater in it.
Yes.
You moved in, decided you didn't want the heater, and someone agreed to buy it from you and presumably came and picked it up.
Well, it was the company, the company that installed it. Yes, we're happy to take it back. They were the value of it that I paid for it was like $10,000. They were going to give me about half the price of it. So they came and took it in February, and then after then I had contact with them on phone and a couple of things. Yes, we're getting back to you. We'll get back. Yes, it's all okay. It's fine.
Juliet, the answer is VCAT.
Yes,
it's an application at VCAT. Okay. You sold them a second-hand heater unit. They agreed to pay you for it. They should pay you for it.
I know, but it's not happening.
No, VCAT.
I don't
VCAT or the Magistrates Court.
Yes. Okay. Fine. Thank you very much.
Good luck, Juliet. Rick is in Atwood with a question. What is it, Rick?
Yes. My partner and I have a property in a caravan park in Mansfield. The new owners a couple of years ago cleared out all the annuals, but there's 11 properties that have between 50 and 100-year leases.
Wow. Absolute madness. Yep.
Anyway, they've... I'm pretty sure they're trying to get rid of us. We're looking to sell our property. And,
so what you have is a license agreement for a site at the caravan park on which you park your caravan.
No, they were permanent shacks built, I believe, after the war.
Okay. But you have a license to the agreement, is that right, or a lease?
A lease.
Yes.
Now, we're looking to sell and move out. They've forced up our rates from $3,500 to $5,500 a year, and we bought another property, and we could use the money. So we've been talking to some of the other tenants, and they're trying to get leases signed off between different family members, and so far the new owners are just ignoring all their requests. They're not responding. Is there some legal reason why they can't or won't sign off on the new leases? And
none that I know of. Rick, there are provisions in the Residential Tenancies Act relating to caravan parks, right?
Yes.
I'll have a look and come back and tell you, but it may depend upon the wording in your agreement.
Right.
So you might need... I will come back next week and give you, for my third piece of homework,
I was going to say,
the principles, but it may well then ultimately depend upon where you go from there.
Okay.
Okay.
All right, terrific.
Thanks, Rick.
There you go. Oh, Dave's going to be busy.
Oh, I went all Friday off.
They're great. You'll have time. David will be here next Tuesday at 10 a.m. That's what we usually do the homework at the beginning of the segment, so just at, about 5 minutes past 10 after the news. And Badu is in Bentley East. What's your question?
Hello, Raf and David. Thank you. I love this segment. 2 weeks ago today, my mum went through an automatic car wash. It's an attended automatic car wash where the attendant directs you to drive onto the tracks and put your car into neutral, and then it takes you through. While she was in there, it stopped functioning. She had to call out and then beep a horn. The attendant came. She ended up being in there for almost 45 minutes. And she's noticed since that there's been damage to her car.
Right, now
So her bonnet has a really decent dent in it. It was like a big, giant mop type thing, not the spinning wheels.
Yes.
And those big mops have like steel plates in them, which the attendant in the end had to manually pull off her car and then direct her to reverse backwards over all the mechanics of the car wash that's pulled her in there.
So was the machine working that whole 45 minutes or did it stop working?
It had stopped, and the attendant, there was a bit of a language barrier, but he was saying that mechanical fault or that there was a mechanical issue. After a while, my mum kind of demanded that she get the owner or a manager on the phone. The attendant he passed his phone through the window to my mum, and the man was just very non-committal, not apologetic, and asked her to hand the phone back. A few days later, her friend said to her, "What's happened to your bonnet? You've got this big dent." She has then contacted the...
So what do you want from us, Badu?
What can she do? She's been quoted $1,600 to replace the bonnet.
She has an action for damages. She can run it at VCAT as a consumer complaint on the basis that the damage occurred during the course of the work being done.
Okay. How does she prove that? And would they be likely to have CCTV that they could show her car going in, normal, out?
They would likely have closed-circuit television. I can't imagine how long they would keep it for. I would be going to look to see whether there were cameras. I would probably be standing outside and taking some pictures.
Would you start with a lawyer letter?
No, because I'd start with trying to get the information to take to the lawyer. Because if they were to walk into a lawyer's office, the lawyer's going to say, what about this, what about this, what about this? Right? You might try and then work out what the machine was that used the wash, maybe do some investigations on Google as to exactly how that works. And then you might try and find out whether or not the damage to your mum's vehicle was consistent with what you're talking about.
Okay.
Right? And
so
take all
he
that to the
won't
lawyer.
He won't answer her call now. When she did call him to say about the damage, he just said he didn't remember if he had spoken to her or not when she was stuck in the car wash.
Yep.
So does she just attempt to find an address?
It's just her voice. It's just going to be her word against his.
Yeah.
But she'll have a credit card voucher that says she paid.
Yes, that's
that will
true.
be able to place her at the car wash at that time.
Okay. All right.
Right.
Okay.
Okay.
Thank you so much.
Good luck, Badoo. Good luck to you and your mum. You've got lots of homework. Get busy.
I'll make a fair fist of it. Thank you, Raph.
David Whiting here every Tuesday at 10 a.m. answering your legal questions.